MSL Presents A Question of Law. Thanks for joining us. What are the new sexual harassment rules issued by the Supreme Court? What liability does an employer face when one of its employees is threatened with the actual loss of a job, demotion, or some other adverse action if the employee does not submit to a sexual advance or a request for a sexual favor? Does an employee have a cause of action when the employee's work environment consists of vulgar jokes or raunchy pictures, but the employee's salary or working conditions don't change? How will the recent Supreme Court rulings affect Paula Jones's appeal against President Clinton? Stay tuned and find out. Joining me today to provide us with an update on the law on sexual harassment is the Associate Dean of the Massachusetts School of Law, Michael L. Coyne, and I'm Diane Sullivan, a professor at MSL. It is my understanding, Mike, that on the final day of the Supreme Court's term, the law on sexual harassment was clarified. How so?
Well, there were some open issues that the Supreme Court had left for resolution regarding what happens with the employee who is exposed to a hostile or abusive work environment or sexual harassment by by a supervisor, but the employee's working conditions don't change, or they don't get fired or demoted or anything else. Can that employee still recover was an open issue. And the Supreme Court told us that there will be circumstances where the employee, even who suffers no actual job harm, can still recover if they properly pursue a sexual harassment claim.
So is it accurate to paraphrase what you've just said, that in the court's pair of holdings, they decided that now an employee can go forward without any tangible adverse job consequences, provided they were sexually harassed?
Yes, they can, provided they can prove sexual harassment, and also that they gave the company, which has a grievance procedure, some opportunity to remedy that harassment.
Are these rulings fair, in your opinion?
I think so. I think what they tried to do is strike a balance between appropriate workplace behavior, which I think we all know is the polite conduct and the no raunchy and crude jokes, and the other end of the spectrum where we have people really exposed to hostile or abusive work environments, things that you wouldn't do to your mother or your sister, but that women and men are being exposed to in the workplace. And what they tried to do is say, listen, if you're exposed to that, then there may be a remedy, but at the same point balance the needs of the employer. If I run a good workplace, I should have a sound policy against sexual harassment in place, but I also should have that policy widely disseminated to all my employees and enforce it. And that's where the rubber hits the road, so to speak. A lot of places have a policy of no harassment, but they don't enforce it and they really don't distribute it. And what the court has asked us now to do is to try and balance the rights of employees to a safe work environment, but also be mindful that the employer should have a chance to remedy problems that are addressed to them in the workplace.
So on balance, would you say that these decisions are good, or are they bad for employers?
I think they're good for both employers and employees, because I think they more clearly spell out the rules of appropriate workplace behavior. And up to now, there's been some real concern as to, well, what is and isn't appropriate? I mean, can I sue my company for the acts of my supervisor that they didn't know about and that I didn't tell them? And most people would say, well, geez, that's pretty unfair if the employer wasn't given a chance. And I think they've told us now that those circumstances where the employer will be held liable for acts of its employees that it knew nothing about, where no actual job harm has occurred, will be few and far between.
So harassment is now defined by the actions of the supervisor and not what happens to the employee subsequently?
It's defined by both. Not just the acts of the supervisor in creating this hostile or abusive work environment and subjecting employees to unwarranted sexual advances, but also is there actual harm that the employee has suffered as a result of it. Absent harm, the employee still can recover, but it's going to be a harder road.
Thanks, Mike. I wonder if we now might take a look at the graphic you prepared for the show, and I wonder if you could specifically tell us when and under what circumstances sexual harassment occurs.
Well, generally, Diane, as the graphic shows, it occurs in two situations. Either when the employee is threatened with actual harm to their continued employment or working conditions if he or she does not submit to sexual advances, or in a second set of circumstances when that employee is exposed to a hostile work environment.
Under what type of circumstances is the employer liable?
The employer is liable either when there has been an actual harm to the employee's working conditions.
Any harm?
Any harm. Any harm. Reduction in hours, reduction in pay, demotion, a loss of job, which happens in some cases. All of that is actual harm to the employee, and all of it becomes actionable by the injured employee, and the injured, not just the supervisor is responsible, but the employer itself is responsible for the acts of its supervisor.
So do these new rules then make it easier for a woman that has been sexually harassed to be successful in a lawsuit?
Woman or a man? No, really, right? I mean, because the Supreme Court clarified earlier that whether it's a male or a female that is exposed to these unwarranted sexual advances is irrelevant. The question is, was the employee subjected to unwelcome sexual advances? Again, I'm not so sure it's easier as much as it's more clearly defined. Some would find, and two of the cases that we will talk about shortly, did find that there wouldn't have been a cause of action, or at least allow them to proceed with a cause of action, but for these new rules. So some are seeing that it allows some employees to advance claims and they might not have otherwise.
Let's then take a look at those two cases that you've mentioned. Let's first start with the Boca Raton decision. What happened there?
A group of female lifeguards were exposed to the types of workplace behavior that most of us, and by a wide margin, would find truly offensive. Their private parts were touched by male supervisors. They were told at one point, or the plaintiff herself, Beth Farragher, who incidentally is now a lawyer, probably in part as a result of what took place here. She was told that if it's either sleep with me or clean toilets for a year. She was exposed to all sorts of vulgar and rude conduct in addition to the offensive touching. I mean, what most of us would find as really offensive behavior. She tried to have it addressed by what she thought was one of the supervisors, as it turned out while it was a police lieutenant, he was not a direct supervisor to be able to take any types of remedial steps for her. But the behavior, in all likelihood, is what most of us would find truly offensive. Her problem, or at least as the court below felt the problem was, is that she really didn't suffer any adverse job consequences financially. She didn't have a reduction of hours. She didn't lose her position. She ultimately quit as a result of the harassment, but the employer didn't terminate her. And up to this case, that's considered to be no adverse job consequences.
Sad as it is. Didn't the city argue in that case that they should not be held liable because they did have a clear policy against sexual harassment?
And a clear policy is a good first step. I mean, if we're talking about how to prevent some of these claims, what we should first think about doing is having a clear policy against sexual harassment, and then the second part would be distributed to all employees so that everyone understands what is and is not permitted. And then the third step, as the Supreme Court laid out in these cases also, is that policy has to be enforced. It's not enough simply to put down on paper, this is what we do, and we really mean it. But the employee should know what is prohibited, the employee should know who to report it to, and once reported, the Supreme Court said it must be enforced in order to have a valid defense of these types of claims.
So that's ultimately the problem in the Boca Raton decision, is that it wasn't enforced or distributed. It
appears from at least the facts that we have at present, and the case hasn't been fully developed. It'll be sent back now to be fully developed. Is the latter. While there was a policy existing, how was it really enforced? Because if it was enforced, the types of behavior we're talking about really wouldn't have been tolerated for a minute. And it would appear from reading the case and looking at it is that this is pretty widespread type of sexual harassment addressed towards female lifeguards. And if there was a policy, this type of behavior wouldn't have been going, an enforced policy, the type of behavior would be unlikely to have been going on as long as it did.
This is what we would call an example of a hostile work environment situation?
Yes, clearly a hostile work environment for these female lifeguards.
Tell me, how does a court determine whether an environment is hostile or abusive? And I understand you prepared a graphic for this as well?
We did. We have a second graphic that in part explains what a hostile or abusive work environment is. And what the Supreme Court in earlier cases told us to do is to look at all the circumstances, including the frequency of the discriminatory conduct, how severe it is, whether it is physically threatening, and we have those situations out there, or humiliating also would be actionable, or simply what we call merely offensive utterances. The fact is that it's probably okay to be merely vulgar in the workplace if that is the type of behavior one would reasonably expect. Finishing that graphic, does it unreasonably interfere with the employee's performance? That's what we have to take is into account the entire circumstances, take a look at the frequency and severity, and try and determine whether it's just merely vulgar or really offensive, and then has it unreasonably interfered with the employee's ability to work in that environment.
Mike, what if sexual content is used? Does that establish, or can that establish a hostile work environment?
No. The fact, and we prepared another graphic on this, the fact that sexual content is used, that someone makes reference to private body parts or things like that, that in and of itself is not actionable per se, what we lawyers say per se, in and of itself. You have to take again a look at all the circumstances and allow the jury to use their common sense in deciding whether a reasonable person in the plaintiff's position would find the types of behavior severely offensive or abusive.
Thank you, Mike. In order to be successful in a sexual harassment action based on a hostile work environment claim, must the plaintiff prove that a reasonable person would find that environment to be abusive, or must the type of allegations be that the plaintiff in fact perceives that that work environment is in fact abusive?
It has to be both. It has to be not only that you or I
assuming I'm reasonable.
which is a big assumption. But we must find that both a reasonable person would find it offensive and someone like this plaintiff. This plaintiff specifically would find the behavior offensive. And it sounds odd to some folks to say, well, it's two steps. Not just that the person themselves subjectively believed it to be a tough workplace from a standpoint of sexual harassment, but that not just that, but that objectively others would find it the same way. And I think what that is in order to do is to make sure that we don't have an overly sensitive or what some would say a prissy person feel, oh my God, you should hear what they talked about today at work. But that this is the type of stuff, not just that they talk today about work, but that no reasonable person would be expected to endure. So it tries to safeguard against those of us that might have much higher moral standards or be maybe well beyond what most reasonable people would consider to be appropriate workplace behavior.
Seems fair to me. Can an isolated incident ever sustain a cause of action for sexual harassment?
Highly unlikely. Justice Kennedy said that in the last pair of cases. What he talked about is occurrences in the plural. So we're generally looking for more. I think there may be a small group of cases where the behavior is of such outrageous conduct that one would consider it actionable in and of itself. But you're not generally, the case law all seems to establish that it's going to take a pattern of activity in order to make the workplace abusive.
Although we're going to talk about Paula Jones's appeal a little bit later in the show, let me ask, if true, were President Clinton's actions enough to rise to the level of sexual harassment?
I think, assuming the allegations are true that we've heard as to that he summoned her into a hotel room and exposed himself and asked that she commit certain sexual acts upon him. I think that is the type of rare case where the single incident of outrageous behavior would in and of itself be actionable. Now, assuming he is her supervisor as the governor of Arkansas and she is a clerical employee working for the state of Arkansas, in all likelihood, I think that might be the rare case, although up to now, the courts haven't agreed that that is the type of situation. What they've asked Paula Jones to prove is where is the harm? What injury have you suffered as a result of this? And that's why her case is presently on appeal. Although that situation may well reverse itself with the latest revelations.
Thanks, Mike. What did Justice Thomas say in his dissent in the Boca Raton decision?
Well, both Thomas and Scalia, and we have to remember, are much more the conservative side of the court. And what they're concerned about in the dissent is that we may be placing too much liability on the behalf of an employer who has done nothing really to this employee, has not seen that her job is suffered or his job is lost, and has no knowledge of the incident. And they're saying that the employer, under those circumstances, shouldn't be liable unless somehow the employer has been negligent in causing the situation to occur. And only then.
You know, that argument astounds me. What justification could there be for saying that an employer is only responsible if there's some type of tangible job harm or if the employer is negligent?
Tell me what I did. If I'm the employer, I'm going to ask you then, tell me what I did to cause your harm, or tell me what I did, what I could have done differently to resolve it. You never gave me the chance to address it. I have a complaint procedure. It's open, it's there. If you want me to try and do something, don't you owe me some level of responsibility to try and help cure that problem?
You have responsibility when you hire that employee, that employee subsequently does not engage in sexual harassment upon me, the victim.
Ever.
Ever.
Ever. I hired you 10 years, and you've had an exemplary work history. 10 years later, at some point, you decide to commit an act of what the employee alleged was sexual harassment. And at that point in time, I'm never told of it, and then some years later, there's a complaint asserted that you sexually harassed a lower-level employee. I can understand Scalia and Thomas's position that under those circumstances, it's hard to suggest that the employer has done something to cause your harm, other than place this other employee in the line of fire. And I'm not saying that that isn't a legitimate reason when there has been a pervasive atmosphere of harassment. But absent that, when the employer doesn't know anything about it, hasn't had the opportunity to address it, there's some merit in Scalia and Thomas's position. I think the majority's right, but it's not an illegitimate argument.
Okay, thanks, Mike. I wonder if we could take just a moment and talk about the facts in Burlington. Mm-hmm. What happened there?
That was another interesting case. It was a woman who was advancing a claim against Burlington Industries. Incidentally enough, she worked for the mattress division. And what happened is not her immediate supervisor, but her supervisor's supervisor was harassing her over a period of time. No touching, but offensive conduct, as she determined it to be. Again, you'd probably rise faster in the company if you were wearing shorter skirts. Geez, Kim, tell me what you've got on today and then I'll answer your question. And it was a lot of inappropriate innuendo, sexual innuendos, inappropriate comments directed to a lower level female employee by a male supervisor. And again, what we had happen is that the complaints were never addressed to a supervisor, didn't follow the company's internal grievance procedure, but then when reprimanded for something else, the employee quit. And 3 weeks later charged the company with sexual harassment.
And what did the Supreme Court have to say in this case?
Well, the Supreme Court said basically used similar language to the other case. This employee, like Beth Farragut, could show no actual job detriment occurring as a result of this. No demotion, no loss of pay, none of the rest of it. And all she could show was the environment was affected by the sexual harassment.
The year of sexual badgering.
The 1 year of sexual comments. Badgering, I think, prejudges the case in its entirety.
I have.
But it does prejudge it in its entirety. There were comments made by someone other than her direct supervisor. Never followed through with any internal company employment and grievance procedure, which there was one, nor did the company, therefore the company didn't get a chance to address it. And the court said that she still has a cause of action, even without the actual job harm, but that Burlington Industries has available to it two valid defenses, that we had an operational grievance procedure that could have been acted upon. She chose not to, and that ultimately will be a factual matter that will be developed before a jury, but it may ultimately bar her claim.
The one thing that really concerns me, Mike, is that everybody, Supreme Court and employers at large, fail, I think, to recognize that a woman may have, and as you'll say to me, and a man may very well be scared to death to blow the whistle on a supervisor who's engaging in harassing activities.
I think that's a really good point. And it's an excellent point, especially in view of the Burlington Industries case, that this is not just my direct supervisor, which is a problem enough because they're going to make my life miserable, but the boss of bosses. This is the person that person reports to. And if a company doesn't follow through on it, and I think this is where the protection that the Supreme Court said is not just a policy, but an enforced policy. And that should give us some safeguards that if these acts of sexual harassment are reported, that the company in fact is going to do something about it, because it is a real concern. What you're saying is that if I report it, will they do something? Because if not, I'm going to keep my mouth shut. Otherwise I'm going to lose my job. And I think that's what will be developed in the next 5 years, is that the court will be asking, well, what constitutes an enforced sexual harassment policy? We might have to look at statistics and see how many out of 100 claims are actually prosecuted. Does the company terminate any of the supervisors when they do these types of things? I mean, a strong message by the company that they won't tolerate it means that they're going to have to take action. We're going to have to school our employees, and we're going to have to make some hard choices and terminate productive employees who engage in this type of behavior. And when the employees know about that, then you'll have what they hope will be the ideal situation.
Mike, both Supreme Court decisions incorporate an identical page-long set of procedures under which harassment cases are now to proceed. What do they provide?
They provide, if we look at the graphic, the Supreme Court established that the employers are responsible for harassment engaged in by their supervisory employees. If the harassment results in a tangible employment action, such as discharge, demotion, or undesirable reassignment, the employer's liability is clearly established. So if we have an actual job harm, then the employer is dead because we've had a situation of sexual harassment. But the employer could still be responsible even when there isn't actual job harm as a result of the sexual harassment, and the employee could still pursue that claim.
Thank you, Mike. Are there any defenses, or what defenses might be available to employers in situations like these? Well,
the Supreme Court, again, in these two cases, the Burlington Industries case and the Farragher versus Boca Raton case, laid out the defenses available for the employer as well. If we look at the graphic, what it talks about is the employer can defend the claims on the basis that it has taken reasonable care to prevent and correct promptly any sexually harassing behavior, such as the effective policy that in Massachusetts law is required of all employers of more than 6 employees, that they have a complaint procedure in effect, and then the last part of this, that the employee didn't take advantage of it, unreasonably didn't take advantage of it, and allow the company a chance to have its internal grievance procedure operate. And that's the last part that you have concerns about, is do we really know that the company will enforce the grievance procedure?
Or that the employee won't subsequently be terminated for some other reason. That concerns me.
And I can understand that. But I mean, remember, the situation in Burlington Industries, the way I'm sure the employer would present it is, this employee was reprimanded for behavior that had nothing to do with sexual harassment. It was not following up properly with sales leads, not returning their calls, and said nothing at the time she quit. And then 3 weeks later determined that she had a claim of sexual harassment. And that's why they would find the claim somewhat dubious. But if the behavior that was going on, engaged in, that the plaintiff alleged, it's a problem within the workplace. If Burlington Industries was smart, they would have had a policy that strictly prohibited that type of behavior, and it'd be a good first line of defense.
Mike, on a different note, will the Burlington Industries decision have any impact on Paula Jones's suit against President Clinton? Because as I understand it, Judge Susan Weber Wright had found that Ms. Jones could not prevail against President Clinton because, in fact, he did not threaten any job harm.
I understand that was the reasoning, but I believed for a while that she could show actual job harm in other ways. And I think some of the testimony that's now clearly not true that was given at the deposition would support her case. Others similarly situated benefited who consented to the president's sexual advances, and that is an argument she sought to make. The other part of Burlington Industries that will benefit her is that she doesn't have to show actual job harm if she can show that it was a truly offensive situation of sexual harassment, which she can. Then we need to know about the second part of it. If Arkansas chooses to defend and the president chooses to defend on the basis of there was an internal grievance procedure,
And you tell me, who's she going to go to?
Well, that's your argument. Now, who am I supposed to report the governor of this state to and get some recourse? And the answer may well be there's no one safely that she can report to that doesn't fall under the supervision of the governor. And that may be the situation that you're worried about, is that this should be actionable in and of itself.
Mike, in another case, a 14-year-old student was accosted by a teacher. And the Supreme Justices decided recently as well that if a teacher harasses a student and the supervisors are not aware of and don't act with what they call deliberate indifference, then there is no liability for the school district. Now, Justice Sandra Day O'Connor, writing for the majority, suggests in essence that while the teacher's conduct is reprehensible and it undermines the educational system, and that the student would suffer great extraordinary harm if subjected to abuse, there's no liability. She drops the ball into the floor of Congress and says, rewrite the law. Why doesn't the Supreme Court of the United States see a need to protect vulnerable students?
They do, and it's a terrible case. I mean, I agree with the passion in which you feel that that case was an error, and I think it is. I mean, I think they feel a need to protect the students, and I don't defend that decision because I think it really is wrong. I think if anything, they could have said there's a higher standard owed to those who are underage, especially when we place people in a supervisory capacity over these students, and we do. That the employer must be, or the employer, in this case the school district, should be more vigilant to ward off these sexual harassment claims because they can have such a horrible effect on the child. So I'm not defending the case, but what they're saying, and this we see in other cases, other decisions, is, listen, as the Supreme Court presently interprets the law, we don't see how the school district is liable for the acts of its employee of which it knew nothing about. If Congress thinks that is should be fixed, then they're the ones that should address it by a new statute. I don't agree with the decision either. But what they're asking for is, if Congress feels that they should have covered it, then they should go back and cover it.
Well, at least at a minimum, I hope Congress addresses it. But it seems to me that a school could be liable if a teacher harasses potentially another teacher, but there's no liability if they harass a student.
That's what's interesting about the case, is that other, especially lower level employees, if you harass you're responsible for. Even fellow employees, if you've created a hostile or abusive, a sufficiently hostile or abusive work environment, you're responsible to at the school district. But for some reason they want to carve out an exception over those that they know that this employee will engage with, which is the students. And that doesn't set good precedent. I wouldn't be surprised if we see that that's changed at some point fairly soon.
Thanks, Mike. In the minute that's remaining or so, let's discuss appropriate behavior in the workplace. Are consenting relationships at work okay?
Between fellow employees, yes. The question in these cases always becomes, is it an unwelcome sexual advance?
What about a supervisor dating a subordinate?
Dangerous ground, but still may be free of liability. Most employers would suggest that would be the type of behavior that in a company policy you would prohibit, because it is very dangerous ground, proving whether it was truly a consensual relationship when one party holds a supervisory relationship to the other.
How about sex jokes?
Not a good idea, and in our company policy it would be prohibited. I know it happens, I get email all the time. It's not a wise thing to do, especially in this age where the rules are now pretty clear. It shouldn't be disseminated, it shouldn't be distributed, and it doesn't make for a safe work environment from sexual harassment claims. I
wanted to ask you about foul language, but we're out of time, so you'll have to come back and join me again real soon. I want to thank you for providing this update on sexual harassment law, and to our viewers, until next time, be well. Thank you.